Mrs. Miletic was a housekeeper at the Royal Canberra Hospital. She was cleaning the nurses' quarters when she moved a bed out from the wall to clean behind it. The bed was on casters on little wheels, but they had become jammed with dust, and as she pulled the bed, she felt unexpected resistance and she fell, injuring herself. The evidence before the court at trial did not relate to this specific bed, but to beds on casters in general. And the expert evidence was, because apparently there are experts in this sort of thing, the expert evidence was that the casters could have been made more safe by routinely applying a lubricant to them, which would also get rid of the dust. This dispute somehow made its way all the way to the High Court, and the key issue in the High Court was the reasonableness of the conduct of the Canberra Hospital in not maintaining the casters. The full court of the Federal Court had found that an injury of this type, while foreseeable, was so unlikely that the hospital was justified in not taking any particular steps to avoid it. It was held to be very unlikely that jammed casters would cause a fall, and very unlikely that the fall would cause significant harm. The High Court said, however, that negligence is really always a balancing act between competing interests. On the one hand, we have the likelihood of harm and the extent of that likely harm, and on the other hand, we have the practicalities of taking steps to prevent the risk of harm. And those two sides bounce off one another. Greater risk is permitted when the cost or effort of avoiding the risk would be very high. However, even slight risks can give rise to negligence if the cost or effort of correcting them is low. The court said, having regard to the possibility of serious injury and to the simple and inexpensive nature of the maintenance procedures which, according to the evidence, would have provided an effective solution to the problem of jamming casters, can only result in the conclusion that a reasonable employer in the position of the Commission would have maintained the casters on its beds. From this case, we learn that where a risk can be controlled easily or inexpensively, the duty to do so is imposed far more readily.